All rise.
The Kosovo Specialist Chambers is now in session.
Be seated, please. Please call the case, Madam Court Officer.
Good morning, Your Honors. This is case CPC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
The record will reflect that Mr. Selimi, Mr. Veseli, and Mr. Krasniqi are appearing by video link, and Mr. Thaçi has waived his appearance in court today with attorney's approval. So we scheduled this status conference to take place today as there are obviously no more prosecution witness scheduled for this week. The panel wanted to take the opportunity that we've been given to discuss timetabling for the conclusion of the prosecution's case, and thereafter I did pass around a brief agenda, and we will address the points in the agenda in the order set out. Just a couple of statements. First, let me ask, I would like to ask the prosecutor, we show next week 2 witnesses. Is that the fact?
Yes, Your Honor, 4745 and 2677.
And thank you very much. So no one else is intended as a backup, or?
No.
Okay. Number 2, there's been some questions, some filings.
Selimi.
Oh. Mr. Selimi.
Apologies, Your Honor, but I would like to inform you that we're not receiving Albanian translation.
Thank you. We will see to that right away, and we won't go any further until that's done. All right, we're testing the system now. Testing.
Oh, that's fine. Thank you. Thank you.
Thank you for letting us know, Mr. Selimi.
Thank you.
Is just so that we are clear as soon as possible, there was some question about the type of post-trial briefs that would be filed, whether they would be simultaneous or sequentially. We will be asking for simultaneous briefs only. So first I want to address the closure of the SBO's case. At the last status conference on 22 January, the SBO predicted or projected that it would close its case by 4 April 2025. I just want to confirm that once again, if that's still the case.
So, Your Honor, 4 April is the last scheduled hearing date,
Yes.
so we would not call any witnesses beyond that date. We were planning until April 15th to file any last written motions that are necessary, evidentiary motions, bar table, Rule 155. We've derived that date from previous indications from the panel, and I can point to page 20535 from the status conference of 1 October 2024, where that date was mentioned. So that's our plan.
So your plan is to close the case on the 15th then?
Correct, but no further witnesses are
Yeah, I
currently
understand.
scheduled beyond the 4th.
Yes, you made that clear. And it has to do with, of course, with some of the other matters that are going to come up in a little while, but I just wanted to have that clear. I want to know if you foresee any issues with calling the remaining witnesses.
Yes, Your Honor, I'll address that. So just to give a brief overview of where we are with the witnesses, also following on from the agenda. As I mentioned, next week we have 2 witnesses scheduled. For the March block, we currently intend to call 1 witness. We'll provide updates on any other witnesses to be called in the March block as soon as we're in a position to do so. In terms of special issues, as we previously outlined in our submissions, in relation to some of the remaining witnesses, we're dealing with complex issues, including witness security, witness cooperation, and the cooperation by third states. But we are doing everything that needs to be done in this regard, and we're doing it as expeditiously as possible. We've recently notified further streamlining decisions in relation to witness lists, and that includes filing 2877 on the 30th of January of this year. And then we also notified the defense of 1 further change via email even this week. We anticipate being able to notify further changes, possibly concerning 3 or 4 witnesses at the end of this week. And these changes will likely entail us seeking to admit evidence of these witnesses in writing, rather than calling them to testify in court. And in line with the panel's previous directions, we're notifying these changes as soon as decisions are taken in relation to them, rather than waiting for any periodic period of time. As Mr. Halling mentioned, we currently don't intend to make any request for any of our witnesses to be heard after the 4th of April, which is what we have scheduled. So that means, if I can sum it up, that any witnesses that will be called to testify in the courtroom from our remaining ones, we intend to call them in the March block. Of course, if something exceptional comes up, we will let you know and make a request if necessary, but that's not anticipated at the moment. So that's just an overview of the witnesses in terms of the courtroom. If Your Honor wants, I could also get into the remaining 153 and 155 witnesses, because that then concludes our submissions in terms of who's left.
So I'm clear, any potential issues that you raised are not foreseen to have changed, will not be foreseen to have changed the closure date.
No, certainly.
The closure date or the last witness date, we'll call it.
No, certainly not at the moment, Your Honor. If anything changes, we will let the panel know. But to be clear, even when I talk about, for example, us having to deal with third states, when we are dealing with those third states, the deadlines we're imposing are deadlines which would make us in a position to be able to then call the witnesses in March or make any written request for the admission of their evidence in writing. So for all intents and purposes, we are doing everything we can so that everyone who needs to come to the courtroom does so by the 4th of April.
Thank you, Judge Smith. I have a question for you, Mr. Patch, on that. And it's really so that the defense doesn't have to prepare for something they should not be preparing for. Have you taken the view that you will drop any of the witnesses that are still on your list, and that at this stage you have formed the view that you will not call 1 or more of these witnesses?
Thank you, Your Honor. In line with the panel's previous directions, if we do, or if we had formed the view that we would remove a witness, we would notify that view immediately. Since we haven't done so from the last time, that means that we haven't made that final decision. We're very aware, and it's obviously a very good point and very fair to everyone. We have no interest in the defense undertaking work they don't have to. So it's very clear on our side that when such a decision is reached, we will communicate it immediately. There is a possibility that among the remaining witnesses, some of them, I don't anticipate it will be many, will be removed. It seems like if those that don't come to court, it's possible, it's more likely they will be converted to writing. If a decision is reached that rather than being even converted to writing or coming to court, they will be removed, we will certainly notify the defense immediately.
Thank you.
Mr. President, may I ask a question?
Yes.
There's some confusion, at least in our team. Mr. Potch said for the March block, we currently intend to call one witness, and then later on, he used the plural. So is it the case that there's only one witness that's intended to be called? And if so, could we be informed of who that is to help our preparation?
I can respond, Your Honor. At the moment, the only witness that we have confirmed attendance for the March block is W04403. That is one witness. In regards to other witnesses that may be called, those have not been identified yet. So as we've been saying, if there's a witness who can testify in March, we will let the defense know and we will put them in the March block.
Does that answer your question? I want to now turn to address any remaining Rule 153 and 155 application. At the last status conference on 22 January, the SBO projected that it would file the final Rule 153 application on 21 February, and that the SBO had one further Rule 155 application to file, but that it was unsure about when this application would be filed. We'd like to know, one, if the SBO still intends to file the Rule 153 application, their final one, on the 21st of February, as stated. Well, let's start with that.
Yes, Your Honor. So we intend to file a Rule 153 request for the witnesses we currently know will be Rule 153 witnesses from our side by the end of this week. The defense has already been informed of the 4 witnesses that will be included in that motion. And indeed, we received a response from the defense about these witnesses with their current position on them yesterday. And I'm happy to report or give you a preview of our submissions, but the defense currently does not object to the admission of 2 of these witnesses pursuant to Rule 153. And in relation to a 3rd witness, the defense would not object to Rule 153 admission, subject to the SBO applying certain redactions to the tendered material, which the SBO has agreed to do. So there will be 4 witnesses in this motion. Essentially, 3 are at this stage by the defense unopposed, subject to the caveat that I just mentioned. As to your question whether this will be the final one, it is likely that it will not be the final one. And that includes because of the ongoing assessment. So of the witnesses who are not scheduled to testify next week, or the one I mentioned, the March block, there's various options for them. Either some of them will come to testify in March, some of them will be 153, potentially some will be 155, as I will get to later, and potentially some will be removed. So as soon as we are able to make a decision on the modality of the testimony, we will file a further Rule 153 requests for those. And to give an example as to why this is also necessary and we cannot file everything by the end of this week, I'm sure, as Your Honours recall, that Your Honours rejected the admission of 1 witness in F9237 that was notified just on Monday, and that means that having received notice of that rejection on Monday, we now have to assess, and we'll do that as quickly as possible, whether we're going to call that witness to testify or whether we'll follow up on a proposal or an option even included in the decision, which is to retender the material of that witness under Rule 153 with certain changes. All that being said, the number of witnesses which would be included in any further Rule 153 request, so after the one this Friday, is necessarily going to be limited in number because we're now dealing with a very small pool of witnesses. As I mentioned, from that small pool of witnesses, there is limited options. They're either going to come to court in March, they're going to be in 153, 155, or they're going to be removed. So the number is limited. Where they go will depend on developments that are taking place very soon and even as we speak. So those are our submissions on 153.
We need to have as much information as possible, and you've given us a lot of general information, but we and the defense would like to know, I'm sure, when these actions are going to happen, when the cutoff date is, when you're going to make the final decision.
Yes, Your Honor. As we've previously submitted in terms of decisions, and Your Honor will be aware, they depend on various factors. They depend on the witnesses' cooperation, they depend on the evidence that is heard in the courtroom, we are still calling witnesses, and they depend on assessments which have to balance all the prosecution's interests and the prosecution's case. We assure you we have no interest in delaying when we file these things and when we communicate the decisions. But again, I think the main assurance that everybody should have is that we will be filing any requests that need to be filed unless something exceptional comes up before or by the April deadline. In terms of the modalities, those are things that, yes, may change. I did mention before in my submissions in relation to the remaining witnesses that this week itself we will be notifying further changes. We will be notifying 3 or 4 witnesses who will likely be converted to writing. Decisions on those will be made before the end of the week, and they will be communicated. And Your Honour, we're being quite specific here. Again, we are not dealing with hundreds of witnesses, 50 witnesses. We're dealing with less than 20 witnesses overall. So from the ones who are coming to testify in the courtroom that I've already mentioned, the ones that are going to be filed in Rule 153 and 155 motions this week, there's going to be 6 of those witnesses. The ones that we're going to notify having changed to writing later this week, that leaves just over a handful of witnesses. So we are by no means dealing with a large number of witnesses, even in terms of any motions that will be made. Those are not going to be large, extensive motions with many witnesses.
Now, the same question about 154 or 155 witnesses.
Yes.
You
so
certainly know who those targets are at this point.
Yes, Your Honour. As Your Honour will appreciate, under Rule 155, there are various reasons why we would submitting. One of them, as you indicated, is quite obvious. We would know now if we're going to submit a witness under 155, should that witness, for example, be deceased. As for the other reasons, which includes, I don't even need to get into them, but there could be issues of intimidation, that kind of nature, unfitness to testify. Those are a little bit more complicated. And so for some of those, I cannot tell you right now, yes, they will be 155 or not, but I can tell you right now that the processes which could lead to determination as to whether they will be 155 or not are well underway for all of them. In terms of filings, we will file a Rule 155 request this week. That concerned 2 witnesses, and the defense already knows which those witnesses are. There will be further 155 requests, as you can imagine from my submissions. Reflecting what I said in relation to 153, those will necessarily be limited in number. There are not many witnesses left on our list. As I mentioned multiple times, though I hope it's clear, those limited number of witnesses are either going to come in March, they're going to go in 153, or go in 155, or be removed. The number is limited.
Thank you. All right, let's talk about the bar table motions. We know you filed one today, actually, or perhaps yesterday. And that had, I think, approximately 300 items within it. Am I correct that there are still 5 more bar table motions to come?
Yes, so I don't know if the number will be exactly 5, but there are more motions. We can group them in different ways, but the ones that are intended already are the Duca-Jean zone motion, which I mentioned at the last status conference and which is projected to be filed next week. I mentioned a general staff bar table motion. On Your Honor's procedure, we send emails to the defense of bar table items before these are filed. We sent that email yesterday for that general staff bar table motion. So that one is going to be, we've given them till the end of the month to comment, and we'll file it in the weeks after that. There are other residual categories of items, international reports, some videos, other things. Whether that ends up being how many motions exactly, we want to group them in a way that makes sense, but there are certain residual categories that will be the final motions. All are projected to be filed by the target date.
Surely you know what items you want admitted, and I'd be interested to know a count on that.
The count, actually, we don't have to hand because we actually assess them regularly as we go through the process. We only want to tender those items that we think are really necessary for the panel to rule on, and so it's a number that's actually changing all the time. The one in the Pastrick motion Your Honor mentioned is just over 300. In the email that was sent to the defense yesterday for the general staff, it's currently 500, around 500 items. But that is the largest projected bar table motion that we have remaining.
So you can't give us a number, approximate.
I can't give a number that would be meaningful, but the number is going to be, if the Duca-Jean motion is similar in size to the Pastrick zone motion and the general staff is the biggest one, I don't think the last motions are going to be of comparable size. So I can give a rough estimate that way.
Pardon me?
We're hanging on the edge of our seat here for the estimate.
Yeah, I am too.
I'm worried that an estimate I give would be off. Also, it's not even accurate to look at it in relation to what hasn't been tendered yet from our exhibit list, because as your honors know, many items from the exhibit list have not been followed through on because witnesses have been dropped. And so their statements aren't going to be tendered. Certain associated exhibits will not be tendered. The exhibit list also has everything in Albanian and English. So, I mean, there's not an accurate proxy of the final number from the exhibit list either.
We're just looking for some help, not an argument why you can't do it.
Right, but these are, the ballpark figures for the next ones are available, and I've given them. And the last motions, it's going to be less than that. Exactly how much less, I can't really say.
This is basically no information. That's not exactly what we were asking for. Do you have any questions of the SPO? Oh, I'm sorry, do you have a question? Yeah.
Thank you, Judge Smith. I have a couple, and in fact, they're more suggestions. But the first one has to do with Mr. Mišetić being on the edge of his seat. We don't want him to fall from it. So I'll make perhaps a suggestion for you to take on board, Mr. Halling. If you are not in a position to give the defense a number, when exactly are you planning to give them that email that you've mentioned for the other bar tables, where you put them on notice of the remaining material? And again, I don't expect, and I think the defense won't expect necessarily to get the full list or a completely accurate list at this point, but at least that they get a sense of the ballpark and the general nature of the material.
Yes, understood. We can do that in mid-March.
In what?
Mid-March.
And I have a second observation, and I'll let you do what you want with it. You have tendered pages of various books, and you've done that in pursuance of our order not to tender unnecessary material. Reviewing some of these, I'll simply observe that sometimes it's difficult to assess the context in which, let's say, a page or 2 pages of a book come. Now, I'm not inviting you to consider tendering a whole book, by no means, but simply that as part of your process, you review these odd pages to see whether the tendering of 1 or more pages or a section of a book might be necessary to give better context to certain parts of this book. It's just difficult sometimes to get to a point in a book or a chapter and to know what was being discussed before, what was being discussed after. But that's your prerogative. It's just an observation on my part at this stage.
Yes, thank you for the guidance, Your Honor.
Also on the issue of bar table, and you've done some of it, but I think you can probably do more. It would be extremely helpful to have inter-party connection with all of these. It could be that a huge percentage of them are going to be an objection to, or that they can tell you right away, this is firmly an objection with us. I strongly suggest, as we come to the end of this prosecution case, that you up the game on inter-party connection.
Understood, Your Honor. We're required to do this for bar tables pursuant to the conduct of proceedings decision. We'll do it every time.
Yeah, thank you. Any questions you have for the panel about these issues?
None from the SPO.
So turning to the defense, the first point, I made the first point, and that was we will have simultaneous filings of the final trial briefs. Secondly, though, we would like to address whether there are any issues of concern for the defense regarding the remaining witnesses to be called. And if so, have you expressed that to the prosecution? I'll just ask you in turn if you have anything to that effect.
we have not had concerns about the witnesses to be called, but that's before we heard the update today. So obviously we didn't communicate with the SPO about them. I'll speak for us. My concern is, first of all, that apparently there's going to be some activity between the 4th of April and the 15th of April, which was alluded to in the prosecution submissions. I'm not exactly sure what is intended to be submitted at that point, but that would seem to us to be late. And I say late because, and this is related to some of the other points, particularly point 6 that you're going to ask us next, but given the volume of material we're talking about now, we can't begin to file or prepare Rule 130 motions if there are literally over 1,000 exhibits on a bar table motion, multiple Rule 153 and 155 applications, and still possibly even more applications to be filed after April 4th. So, and I anticipate now that, frankly, for staffing reasons, for our team in particular, some of us are involved in 2 cases now, the volume of material to have to address within 30 to 45 days before the scheduled close of the prosecution case is quite significant and is going to be very burdensome for us. And I just let you know that right now.
Trust me, there's only 8 of us doing this, and we have to go through it all also. So I understand that.
Yes. And you know,
it's a tough job, but somebody's got to do it.
Absolutely. But, you know, one of the things is if we have a bar table motion that we received yesterday of 500 and something exhibits that are titled General Staff and PGOK bar table motions, those are obviously documents that we're going to have to take a careful look at each one of those documents given their relevance and importance to the case. We've been given a deadline to respond to the SPO, I think, by next week, which is highly unlikely that we're going to be able to go through that amount of material in 2 weeks. I say this just because you need to be aware that given that volume of material, things are likely to slow down, and then more bar table motions coming on top of 153s and 155s. So it is going to be problematic for us. We, of course, are going to do our best to respond to keep this case moving forward because it's in our client's interest to keep it moving forward as fast as possible, but it's an issue.
All right, the next item is a difficult one.
Could I just add on this matter? Our submission would be that the prosecution would not, in fact, be able to close their case on the 15th of April if they're still filing motions and we're having to respond. There might be replies, and your decision has to come as well. They'll only be able to close it once all final decisions have been made, and then the
rule says when all witnesses have been heard and all materials have been presented, then they close their case. It does not require us to have answered each and every motion.
Yes, Your Honor, I think the other way of looking at it then would be that we would say that the time for considering and filing the Rule 130 motion could only start running from the time we know what the final body of evidence is. So,
unfortunately, the rule doesn't say that either. It says very specifically that when they close the case, you must immediately advise us whether you do or do not intend to file a Rule 130 motion.
yes, well, if I could say, our submission would firmly be that we have to know what the case is, logically, before.
Talking about what you believe, I'm
Yes.
telling you that's what the rule says.
Yes.
And
Well,
we have to deal with that rule.
Yes. So we'd also, John, take that into account in scheduling. Really, that's our submission, to allow for enough time for us to be able to respond to all of the motions, some of which might well only come in on the 15th of April, and to take into account your honest decisions as well.
I think the rule envisions that you will continue to advise yourself about what's being filed and be in a position to say yes or no whether you are going to file the motion immediately. We will do our very best to get the answers out, and you certainly can't be expected to do a final argument, a brief, without having all the answers given to you ahead of time. But the Rule 130 motion is quite specifically set out in the rules, and we intend to follow it.
Yes, Your Honour, we also want to move this along as quickly as possible.
It doesn't have to do with quickness, it was just compliance.
Yes. But Your Honour, we just want to ensure that fairly we have enough time to take everything into account before we have to file the final 130 motion if that's the route that is followed. So that to be taken into account in the schedule is really what our request comes down to. And Your Honour, one or two further matters, just briefly. The first is in relation to the number of live witnesses potentially still to be called, as His Honour Judge Metro has outlined. We've calculated that it's at least 10 further potential live witnesses, in addition to the one in the March block. And we would ask, because it's a lot to prepare for 10 potential live witnesses if they're not going to be called, that there is a deadline set that by the end of this current block, so by the end of next week, the prosecution notifies if, in addition to the one, there are any other live witnesses to come. Of course, the applications can still be filed if they're not going to come, but at least we know then by the end of this block whether we're having to prepare for 1 or 2 or 3 or potentially 10. It's a big difference in terms of resources which we could direct towards addressing motions rather than preparing for witnesses who aren't going to come. So that would be our request, that some deadline is set for them to notify us about live witnesses. And then the last matter, Your Honour, we would request that there are reasons given in respect of your decision on simultaneous briefs. We did file motions.
We'll file an order, for sure. No question about it. I just wanted you to know as soon as possible.
Yes, we'd be grateful for that. Thank you, Your Honours.
And do you want to respond to the request on the 10 witnesses? Please try to be as specific as possible, because we're getting close to the end and we need to have this information.
Yes, Your Honour. The number that Council just referred to, that's 10 remaining Live 154 witnesses, as in 10 witnesses for whom we already said would be Live 154 till now, is correct. Now, as I've said before, of those 10, likely many, or at least some, will be changed to 153, 154, or removed. We do not anticipate that all 10 will be added to the March block. As I said, we're not even envisioning calling beyond that. In terms of setting a deadline, that would be arbitrary, and the request to set a deadline indicates that the issues at hand are not being well understood. Those issues being witness cooperation, witness security, and in particular also cooperation with third states.
Just a second. You know who you have problems with. If you don't, I don't know what you've been doing. You do know, and it's time to start saying these people have potential problems that may cause these particular people not to be called, and the defense needs to know that.
Yes, Your Honour, that is of course something that we do know. We do know who we have issues with.
You know who you want to put on the stand and who you're sure is going to be on the stand, and I'm sure you have some that you're unsure about. You need to communicate that as soon as possible.
Your Honour, to be forthcoming, I don't see the value of informing the defense which ones we may or may not call before a decision is made. There's no point in telling them this one may not come or we have issues with this one.
You're missing my point. You know some that you do want on the stand and you're sure are going to go there.
Your Honour,
correct?
Of the 10 witnesses, we do want them on the stand. The reason for them not to be on the stand would be issues that are being worked out. If we're not able to put them on the stand, we will seek to admit them in writing, or if absolutely necessary, remove them.
By when?
Yes, Your Honour.
Because if you can't come up with a reasonable deadline, we will.
Certainly, Your Honour. As I mentioned, there is the March block that ends on the 4th of April. We'll make applications as they come. We are not saying that we're going to notify the defense 1 week in advance that a witness is going to show up. If for any of these witnesses we schedule them and the defense argues that there has not been sufficient notice, we will take that into account and take it from there. But in terms of setting an arbitrary deadline, that does not fit in with our working at the moment.
Mr. Pace, excuse me for interrupting, but it's not only for the benefit of the defense, it's also for the benefit of the panel. You have probably noticed that the panel is also preparing witnesses and in order to ask proper questions. So it's important that we also know who you are going to call or who's off the list.
Yes, Your Honour. And
we're going to have to
please
consider
as early as possible.
Yes, and just to respond to Judge Barthes, as I said, this week itself we are notifying 3 or 4 changes, so that will address some of those 10 witnesses. And in view of Your Honour's comments now, we will also provide a further update next week. And as I mentioned, we are providing the updates as soon as we are able to give them.
Yes.
Mr. President, it's not arbitrary to set a deadline. Paragraph 77 of the Order on Conduct of Proceedings requires them by next Thursday to let us know who the witnesses are going to be in the March block.
Yes.
So there already is a deadline. The second point to raise is these issues with these witnesses, I'm sure, have been ongoing for months in their efforts to secure them, if at least weeks, if not months. So it's not like this has popped up today and they need extra time to figure out whether these witnesses are going to come. We would ask you at the very least to enforce the existing deadline in the Order on Conduct of Proceedings, and that by next week, Thursday, they make a commitment one way or another as to whether these people, they intend to bring these people live or not.
Yeah, and we intend to do that. And we didn't make the rule, the Order on Conduct of the Proceedings just for window dressing. We actually intend it to be used. So please arm yourselves accordingly. I take it you're not in a position today to say whether or not you are more likely than not to file a Rule 130 motion, or more likely than not you won't.
I will say two things on this point. First, you will recall that I had asked a question of the bench at the last status conference, which will, at least in some measure, inform our own decision on Rule 130.
Yes, and it does, and we're aware of that, and we appreciate that hint.
Okay, right. Okay. So that's the first part of our submissions from the Thaçi defense. Secondly, at this point, I think it's fair to say, with that caveat, and in the absence of information from the panel, that we should prepare as if there will be a Rule 130 motion, just for your own planning purposes. But that may change depending on a number of factors, one of which is the question that I posed to the panel at the last status conference. Thank you.
Yes, Your Honor, on behalf of the Vasily defense, likewise, in principle, we should proceed on the basis that there would be such a motion, but it depends on a number of factors that are under consideration. Yeah. But more likely than not, in the terms that you used, Your Honors, so that should be included, as we said before, in the schedule. And of course, if anything changes, we would notify Your Honors immediately.
The problem with putting together a schedule that's based on one thing and then it changes, it means the whole schedule's out again. So we simply cannot do a proper scheduling until we know the answer to that question. And I understand the limitations. I'm not arguing about that. I'm just telling you the scheduling of pretrial briefs, for example, will be done by us at some point, but after that decision has been made. There's no reason to do it ahead of time because we don't know how long all of it's going to take. We don't know how long the 130 motions are going to take if you file them, how long we'll need to deal with them. We just can't make that kind of give you that kind of an answer. So, and it's specifically because you asked at the last meeting if we could calendar some of these things and get them set. The answer is we really can't until we have the 130 answer, and maybe you don't know what you're going to do, and maybe you do, you certainly don't have to tell us. But that's the problem. That's the roadblock that's in front of us.
Yes. Your Honor, our request was whether it was possible to set a tentative schedule to say that in the event that there were 130 motions, this is how long you'd be given. So we know, and this is how long the prosecution would be given to reply, and then thereafter, this is what the next step would be as a tentative schedule, so that we'd know what would happen.
Well,
in the
I think
event.
you already said you wanted 3 weeks.
We said 4 weeks.
4 weeks?
Yes.
Okay.
From,
and I'm sure that the
from a reasonable
prosecution
date.
would have at least 1 day.
We asked for a reciprocal extension of a month, which, if that is
Yeah.
acceptable to your honors, actually resolves many of the issues Mr. Misitich was raising earlier.
I can tell you that request is reasonable. The 4 months, 4 weeks, 4 weeks, 4 months.
4 weeks.
4 weeks and 1 week. And
4 weeks.
4 weeks.
and 4 weeks. But you also had indicated that you wanted to have, I think you said 10 weeks for doing final briefing. We have no problem with that request. It's just putting it into a calendar, it doesn't make any sense until we know where we're going with this. But if it'll ease your mind a bit, you will be given that kind of latitude in filing a final brief.
We're grateful, Your Honour, for that indication. At least it allows for some planning to take place. Nothing binding, of course, but on the basis that those guideline timelines are broadly acceptable.
Yeah, and the summer break has some impact on all of that, but we'll deal with that at the time. But the time you requested is certainly reasonable. And we don't, after 2 years of trial, we certainly don't want to start cutting it back on your final brief. So it will be there. And then there'll be a reasonable period of time, since they are simultaneous briefs, to absorb the other brief so that you can make any comments or replies that you wish you think are necessary.
And of course, likewise with any defence case as well, and the preparation of that and presentation of that, the guidelines that we have set out in our proposed timelines, as long as those are broadly acceptable, it gives some idea of
They're broadly acceptable. Yeah.
planning forward.
Yeah. Thank you.
We're grateful.
Mr. President, may I just raise one issue? I apologize, but it's related to a point you were making earlier about Rules 129 and 130. I understand the way the rule is written, but our position would be that the prosecution is not going to close its case until there have been decisions made on whether the evidence it's tendered have been admitted or not. The case can't be closed if there's still pending evidentiary motions.
Their case could be closed, and we have to rule on the motions. And unfortunately for them, if we disallow something, there's not much they can do about it at that point.
Okay, but then I don't know how we can submit that there's insufficient evidence without knowing what the evidence is, particularly when we're talking about potentially over 1,000 exhibits.
If they'll hurry up and get these all on file, we'll at least know what they're talking about.
I agree with you, but then again, I still go back to the point, given that we may know some of the issues we would raise, but those documents may be related to the issues we would raise, then are we arguing in the hypothetical in a Rule 130 submission?
For myself, Mr. Micetic, I think you said it the last time. The rules are what they say, so the case of the prosecution would be closed. But your position, with which I would agree, is that the 130 could not be rendered until and unless the admission decisions have been rendered. In other words, you would be in a position to argue your case based on what you know is on the record.
Okay, thank you. Just so that we're clear. Thank you.
Yes, and Your Honors, if we could just briefly respond to that,
Sure.
because we think that submission is itself hypothetical. As Your Honors know, and as is set out in the Case 7 Rule 130 decision, a Rule 130 decision, at least if the same principles are followed, are done count by count, and the evidence is only cited for illustrative purposes. It seems exceedingly unlikely with the way these counts are designed that tendered, unadmitted material is going to make much of a difference in the resolution of the Rule 130 decision. The defense does not require this information to file their motion.
So, Mr. Halling, do you want the defense to make submissions not knowing what evidence has been admitted? They have to guess and assume?
Well, we certainly don't want to put it on the panel to have to resolve every pending motion in the 1 month after the case closes. So it's up to the court if they want to set that record. All I'm saying is that this is not a requirement for filing a no case to answer motion. It is perfectly clear that if something is tendered but not admitted, what its status is at that moment. It might be used by the panel, it might not be, and the submission can be made accordingly.
We obviously strongly disagree with that, and also think that the submission that was made earlier about what Rule 130 means with respect to counts or partial counts is something to be litigated, and we have the right to litigate it. Thank you.
Mr. Micetic, I want to return to the question that you asked the panel at the last day's conference. I'll just read it out. You said the question would be, if there is no defence case to be put on, and the defence challenges the sufficiency of the evidence, so that there's no case to answer, would the panel be prepared to move straight to preparation of final briefs and closing argument? That was your question. So my understanding is that if there is no Rule 130 stage at all, and if all 4 defence teams elect not to put on a defence case, well then logically one must move towards final briefs and closing argument. What else is there to do exactly?
I agree with you, but I would just like you to confirm that. If that's the case, then that's the case.
I don't
We
see
have
that the
one
rules-
other, we have a participant that is being
Well,
left out of the
May I
argument.
just
We're
interject
getting
to
to
say,
you, you're next on my list.
Yeah, if I,
I
Certainly
feel like
the-
a submission at this point might be
Certainly the
helpful.
victim's case would take place for sure, but
yes.
but if none of the defence teams are going to put on a defence case,
Yes,
there's no 130.
let me-
We have to go to.
Let me then address what the issue is. Rule 127 says specialist prosecutor goes first, defense, if any case, victim's counsel would go, per our agreement, he would go after the SPO. Then in the defense case, if any, then evidence called by the panel pursuant to Rule 132. Our question essentially is the panel, our position is that if we say they've failed to meet their burden of proof and we wish to challenge that at that stage, the role of the panel then moves to, okay, we're challenging the sufficiency of the evidence, and we go straight to final argument.
So what you really want to know is the panel intending to call witnesses?
Yes, and especially if there's no defense case, I don't want to make submissions on the point, but that would be problematic in our view because in effect, the panel would be potentially weighing in on the side of the prosecution in a situation where the defense is saying, we're challenging that they've met their burden of proof.
I understand. Thank you.
Now, go ahead.
Sorry, thank you, Judge Smith. Mr. Michetic, I have another question for you, just a housekeeping matter. I'll be as generic as I can. You'll understand why. But on the 14th of September 2022, you made use of a document. It was a report of March of '99 from an organization. The ERN is DHT 02008 to DHT 02010. And at the time, you were queried whether you intended to tender these documents, and you indicated you needed further clearance from the provider. I just wanted to know whether there had been any movement on that front, and if so, what you plan to do about it, if you are in a position to say, of course.
I do believe I remember the document, and you are correct, and I believe we have received clearance to submit that, so we will go ahead and tender that at the next opportunity.
Thank you.
Thank you.
Now, Mr. Laws, we saved the best for last.
Well, nothing to add really. I wanted to just to point out the missing part of the chronology as it was developing, and I think that's been acknowledged now. So we've nothing to say.
And we're aware that you need to have some sort of guidance so that you can get your expert available to you. Is that still true?
Well, we are in the process of instructing experts, and the one that's going to take the most time is fully instructed and is in the process of preparing a report, and we'll be in a position to serve that report in April, no question of that. Plainly, the whole issue of when the prosecution case is closed and what closing the prosecution case means and whether there are Rule 130 applications, all of those have an implication in terms of when we are required to put on our case. But it doesn't seem to me that I can do or say anything useful in that regard. We just have to wait and see how things develop.
Thank you. Anybody else have something or anything that you wish to bring to our attention? You do? Oh. Start here first.
Thank you. And I have a question for the defense, just so that we are clear about your position on 130. Is it the defense position that you are not able to decide whether or not to file such a motion until the point when we've decided all pending application? I'm not speaking, just to be clear, Mr. Michetic, I'm not asking you to make your submissions before that point, but whether you will be in a position to tell us whether you plan to file one or not. When would that be? Only after all bar tables and 15345 have been dealt with?
I think we would be in a position, first of all, again, with the caveat that we're waiting for a position on the panel on the question that I posed. But we would be in a position to say whether our intention at the time is to file a motion. But again, we would reiterate that we would not be in a position to actually prepare and submit it until we have final rulings from the panel.
So you'd be in a position to tell us whether you're going to file one or not by the end of the prosecution case. Did I get that right?
Yes.
Thank you.
Yes, so that would be, as I understand it, 15 April, we'd be able to give that indication. But we'd ask, as I said earlier, that the 30 days start running from the date when we know what the final state of the evidence is, including whether important witnesses may be introduced through 153 or 155. That's all important to take into account for each and every count that we might wish to challenge in any 130 motion. Thank you, Your Honours.
Just for what it's worth, from day one, I've considered April 15th to have been the end of the case. This April 4th figure only came up in the last month or so. I've always considered it to be April 15th because I think that's what that was the day we started, was on April 15th, 2 years ago. Anybody? Yes, you had something else?
There was just one last aspect before leaving the possible defense case that we wanted to mention now. There's been discussion about when the defense would actually start opening and presenting its evidence in the event that they do choose to bring a case. But there is an earlier deadline related to that, and it's the Rule 119.2 deadline
Yes.
for witness and exhibit lists, which really hasn't been discussed very much in these hearings. In Case 7, it was done within a few days of the Rule 130 decision. That's a very important deadline for us. It's what really starts our ability to investigate and seek cooperation as needed for the defense case.
I believe we will be dealing with that issue as soon as possible after the closure of your case.
Understood.
That's what we did in the previous trial that we were involved with, and there's no reason to do otherwise. To set the time for presenting evidence can be done, so that will be our practice. Anybody else have something to weigh in on?
Your Honour, there was just one request in relation to the recent bar table motion that was filed yesterday, F2944, and that's to ask for an extension of 7 days to respond to it. We've heard that it's over 300 documents. The prosecution does not oppose us having a further 7 days to file by Friday, the 7th of March. That's in the break.
Are you going to want to reply or not?
It depends on what the response says, Your Honor. I think it's likely there'll be something to reply to.
It's just that it's a lot of material to consider.
The extension is approved.
Thank you, Your Honours.
I said I don't know if we solved anything, but we did talk about it. Everybody knows where the concerns lie, and that helps. So we will see you Monday. Monday. And thank you for being here today. I'm sorry there was a short notice, but we were in hopes that there might be more than one witness this week until it was obvious that there wouldn't be. So we'll see you on Monday. We're adjourned.
All rise.